Good morning, everyone. Welcome to court. Today we get to look at the third case of this illustrious courthouse. The case is called the Tuition Tention. In this case, today, you are going to be introduced to our honorable judges. We would like to call the honorable judge, Chief Judge, Miss Elizabeth Pratt, Judge Dr. Patrick Jackson, and Judge Mora Daphna Bar Yosef. Please rise for the judges. Shh. Allow me to introduce to you the rules of the court and what you should expect today. In order for you to understand what's going on, you need to be shrewd. You need to listen to details. And above all, you have to be able to see through the noise and the theatrics. For justice to prevail, it really requires you to be unbiased, to objectively listen to the facts, listen to the arguments, and think to yourself, which of them presents the angle of ethics and morals that should sway justice in favor of who's innocent and to convict the person that is guilty. Today, we're going to begin by introducing to you the case. You can hear from the plaintiff and the defendant themselves as they tell you the facts of the case. After that, every single one of you are going to get a chance to vote on what you think just based on your initial reaction. Before you hear arguments, before you see evidence, just on your initial gut reaction, who do you think is innocent and who do you think is guilty? We're then going to introduce the plaintiff and the defendant counsel. They will begin by giving us their opening statements. They'll move on to giving their witnesses' testimony, and then they'll have their closing statements, and the audience will have a chance to vote again a second time after hearing the facts and the evidence. The jury will get a chance to vote, both the middle school and the upper school, and of course, our honorable judges will give their vote as well. They'll give their judgment as well. Let me introduce you to today's case. It's actually a really special case. Rabbi Chaim Jachter, who many of our 11th graders and 12th graders are learning from his books, Gray Matter, is a Dayan, a rabbinical court judge in the Beit of Elizabeth, New Jersey, and he's an educator and author of 20 books and over 1,000 online and journal articles. He serves as the rabbi of Sha'arei Ora Sephardic congregation, even though you could probably guess from his name that he's an Ashkenaz rabbi, which is fascinating. He had this case that we're going to talk about today. He sat and he argued with a courthouse that ruled one way, and he felt as a judge that the ruling should be different. So by no means is this an easy case. Let me tell you about the tuition tension. Putting it simply, we have a gap year program in Israel that gave an education to a child for 1 year and then a second year. Year one, they agreed on a certain amount that they're going to pay for tuition. Year two, the school felt that they should receive more money. The father refused to pay it. The child attended second year in that school, hasn't paid yet. And what is at question today is, what is the right amount of tuition that this father should pay? Let's hear from Rabbi Jachter.
Hi, this is Rabbi Chaim Jachter, greeting my friends from the Jewish Leadership Academy in Florida, sunny Florida. Woo-hoo. Way to go. So first of all, thank you for taking an interest in my svarim. I think you learned from my Gray Matters, which is fantastic. I'm really glad you do that. And I hear you're having a great based-in debate about a very important debate that I have with the Beit of America about this case about a father who argues that he doesn't have to pay anything to a Beit-in. Not to bet, and they didn't pay anything for a shana bet that if his son attended in Eretz Yisrael, even though he willingly sent the son, paid for a flight, he claims he doesn't have to owe anything. The yeshiva thinks that he has to pay $24,000. How do we resolve this dispute? It can go either way. Beit of America thinks one thing, I think another. What do you guys say? I'm eager to hear what your thoughts.
So here we have the case. The question is the father obligated to pay the full tuition of $24,000 for year 2 of his son's gap year program? And now you're going to hear some of the details. Pay attention to the details of the case.
Thank you very much, Clerk. The record is now open. Court is now in session. We would request that the plaintiff and defendant be prepared to stand before us with their facts of the case. We would first call the plaintiff to the stand.
Do you affirm to say the truth and nothing but the truth so help you God?
Mirza Hashem, I do.
Welcome. While normally attorneys would be the ones posing the questions to you, in the interest of time and clarity of the record, I will be the one who is requesting questions of fact to get them onto our record for a clear understanding of what happened in this matter. Are you prepared?
I believe I am.
No need to be nervous at this stage. I'll keep the questions easy. Please start by stating your name and who you represent.
Baruch atah Adonai Eloheinu melech haolam she'akol nihiyeh b'dvaro.
Amen.
I'm sorry. I'm simple administrator at a yeshiva. Could you state the question one more time, please?
I'll repeat the question. Please state your name and whom you represent.
My name, Baruch Hashem, is Baruch Mendelson. You might know me as Barry. That's what my mother calls me. She should live and be well, and I represent the yeshiva.
If you would, please state your claim clearly for the Beit Din. What is it you're asking us to rule?
It pains me to state this, but we are asking the Beit Din to rule that the father is obligated to pay tuition for year 2 of his son's education in our humble yeshiva in the amount of $24,000.
The record so reflects. Now, I'm going to ask you a few questions about the facts of this case. As a reminder, at this point, we are only asking for the facts of what occurred. We will not be citing to any legal sources, nor will we be entertaining legal arguments at this time. Are we clear?
Yes.
Did the defendant's son attend your yeshiva for year 1?
He did. He's a wonderful Talmud, wonderful student. Yes.
Thank you. And was a tuition agreement in place and signed for the Shana Aleph?
Baruch Hashem, it was, yes.
And what was the listed tuition for year 1?
The listed tuition for year 1 was $24,000.
How much was ultimately paid for year 1 by the defendant?
Ultimately, we worked it out that they paid us $12,000.
Could you clarify for the record, worked it out? What does that mean?
We work our hardest to bring everyone to our yeshiva, everyone who could be there, whatever we can arrange. So we offered a $12,000 scholarship. We reduced the tuition price by 50%.
Okay. And that $12,000 was paid, correct?
Yes.
Okay.
Yeah, Baruch Hashem.
And did the son return for the second year in yeshiva?
Yeah, we love having him. He came back.
Okay. And was there a tuition contract sent for year 2?
We did. We sent a tuition contract.
And was that contract signed by the defendant?
No, I don't believe they signed the tuition contract.
You don't believe, or they did not?
They did not.
May I ask why the contract was not signed, to your knowledge?
I don't want to make any accusations. I'm just a simple administrator, but the Abba, the father, refused to sign it because he claimed he didn't want to pay that amount, he didn't want to pay the tuition. It was very difficult.
Okay. And what was the tuition amount that was listed?
We had listed that the full tuition was owed, for year 2 in our yeshiva, which would be $24,000. And we were able to offer a scholarship of $2,000 for a total of we would reduce 24 by 2, it would be $22,000.
Okay. And did the son attend the full year, Shana Bet?
Baruch Hashem, he was there, he learned, he steiged, he was one of our best Talmidim, our best students.
So that's a yes.
Yes.
Thank you. And did the yeshiva receive any payment tuitions towards year 2?
And we have not yet received any tuition for this very wonderful boy's second year in our yeshiva.
Have any efforts been made by the yeshiva to secure the payment?
Yeah, we sent messages, we made phone calls, we tried, but we were ignored.
Okay. No response of any kind from the father?
No, I'm sure there's a reason, but he didn't respond to the messages we sent.
Thank you. You may step down.
Just thank you so much for everything you're doing for us.
At this time, the court calls the defendant to the stand. Clerk, would you swear in the witness, please?
You affirm to say the truth and nothing but the truth, so help you. Yishtabach Shemo?
Yishtabach Shemo, absolutely. I'm here to tell absolute the truth.
Okay.
We should hope so.
Great, Rabbanim. Thank you for having me.
Please state your name for the record.
My name is Dawid Razan Bar Yochai.
And are you the father of the student in question?
Yes, I am his father. It's a wonderful boy, really a wonderful man.
Okay. Please state your claim clearly. What is it that you are asking for our court to rule today?
Well, it's very simple. I mean, my son went to yeshiva and really had a very nice experience, and he learned a lot, and it was wonderful. And now it's time for him to move on with his life. And he says to me, "No, Abba, I need to go back. I need to go back another time for a more year." And I say to him, you know, who's going to pay for this? You know, and the yeshiva comes to me and they say, "No, your boy is so good. He needs. Of course, he's very good. You know, comes from a good family." And they say, "Where's it going to come? Got to come back." And I say, "Well, I'm going to pay for all this."
While your family situation is understandable, there are no easy answers in this case. I do need a clear one. What is it you are asking this court to rule?
Yes, I want to know from the court to understand, of course, that my son got a good education. The yeshiva is great. It's really great. But, you know, they ask for a lot of money. I needed they to know. And I told them this at the beginning, and they tell me, no, it's $24,000? That's crazy. That's a crazy number. He's got to go to college after this. And I say to them, no, I can't go back another year for this $24,000.
So for purposes of a clear record, I'll rephrase the question. You are asking us to rule that the yeshiva is not owed $24,000.
No, yes, that's right. I will pay half. I will pay $12,000. That's what I can pay. And,
okay.
Yeah.
And so the record now reflects the counter offer is $12,000. All right. You are reminded at this stage that we are only seeking facts as to what occurred here, what happened. No legal argument is to be made at this point,
yes,
nor
of course.
legal sources cited at this time. There shall be time for that later.
Yes,
Do you understand?
Of course, absolutely.
Okay. So my first question is, your son attended the yeshiva for year 1, correct?
Yes, he did.
And you signed a tuition contract for year 1 only, correct?
Yes, they gave me a nice tuition, $12,000, and what I would pay again.
And you agreed to pay that tuition?
Yes, absolutely.
Okay. And that was $12,000 you said, correct?
$12,000, yes.
Okay. And did the yeshiva then send you, well, first, I shall ask, retracted, you paid in full the $12,000 for year 1, correct?
I don't remember how exactly I paid. Some moving the money around a little bit.
But at
I
this
figured it
point,
out.
year 1's...
Yeah, I paid.
Okay. All right. So the facts are stipulated that payments were made in full for year 1.
Yeah, I think so, yes.
So now for year 2, was the yeshiva responsible for sending you a contract?
They did, but we did not agree on the contract.
Okay. But you received one.
They
Not that you
sent
agreed.
me something after I told them many times that it was not the right contract.
Acknowledge the record reflects a contract was sent but not agreed to. I take
Never
it
agreed.
you did not sign this contract.
Did not
then.
sign the contract.
So you told them the reason why, correct?
Yes, I told him many times that just like the first year, I cannot pay $24,000.
You cannot pay $24,000. That was the reason you communicated.
Yes.
And did you communicate this to the university? You told them?
Yeah, I told them many times, many times.
Many times. Many ways? Was this verbal, written?
Yeah, I don't remember. I mean, there may have been a phone call or a chat in the hallway.
Okay.
It was in the office. I came into the office one time.
Thank you. Did your son nevertheless attend the full year two?
He did. And he had a very good time. He had a very good time in the yeshiva. I don't blame the yeshiva for what they're doing. I cannot pay the $24,000 and I never agreed to pay.
Did you make any tuition payments at all towards year two?
No, because we did not have a contract, and I want to make sure that if I'm going to pay, that they know that this is how much I can pay.
Understood. Thank you. You may step down.
Thank you very much, Rabbanim.
At this moment, I'm going to ask everybody to pull up your laptops or your iPads. What you are going to see is a poll. The question is the father obligated to pay the tuition for $24,000 for year two of his son's gap year program? Yes means that the father is obligated to pay. No would mean that the father is not obligated to pay more than $12,000. You're looking for the one that's blue that says initial poll. So there are two tiles that show up on your desktops. One that says initial poll. Take 30 seconds, just a yes or a no.
As we are waiting for information from the jury and the polls, we now accept that by stipulation of the parties, the facts have been entered and shall be assumed as true unless later challenged through additional evidence. At this time, a reminder, no legal arguments have been presented. However, at this time, we would like to summon before the court the plaintiff and defendant counsel.
You're reminded that you're in the middle of court.
Thank you, Clerk of Courts. A reminder to all parties and to the gallery that these proceedings must be performed with decorum, quiet, and attentiveness. This is not a show or a spectacle. This is open justice, as it was meant to be done. Should anybody interfere with those proceedings, including by breaking the decorum, the bailiff has been instructed to escort you out. Counselors, for both parties, are you prepared to deliver your opening statements?
Yes.
In such matters, it is customary that the plaintiff leads the way. Therefore, I invite plaintiff's counsel to make your opening statement.
With permission of the jury, the judges, this honorable courtroom, we are here to make sure justice takes place. We need to recoup here a loss of funds that my client directly incurred due to generosity of our school, respecting and allowing this man to send his child to our yeshiva. And even if their defense tried to raise their greatest points, that they would try to work something out eventually. Objection, Your Honor.
A reminder, defendant's counsel, that you are meant to be demonstrating to your client what proper decorum looks like, lest you compromise his case. Carry on, counselor.
Can he object to his own statement?
I'm objecting to him talking.
To the behavior, sir. Thank you.
Our school generously tried to offer a tuition discount. The amount that our school could offer, what we had from our donors. However, we got no answer as we tried to track down this father. For an entire year. Once he received the stipulation that his tuition would be X amount, the choice was simple and honest. Either you withdraw your son from the yeshiva and pay the full amount, or stay there and pay, or just leave and pull your son out of there for an entire year. Housing, meals, teachers, dorms, electricity, complete education every single day. And now he says, because I didn't sign, I owe $12,000 instead of the full amount that he clearly knew he was obligated to. Anyone can take services and avoid paperwork and walk away This isn't a negotiation. This shouldn't even be a negotiation. This isn't confusing. Taking what doesn't belong to you is wrong. We will prove three facts. He knew the price. He stayed anyways. He accepted all the benefits. And Jewish law, fairness, and basic decency will all attest to the same thing. And we ask for our jury to find in favor of our plaintiff, and make the defendant pay the full amount.
Thank you, counselor. All right.
Too long, asking too long, too much money, too much talking.
Counsel is reminded that your role is not to testify, merely to offer legal argument. Come forward. Counsel for the defense may now make their opening statements.
Ladies and gentlemen of the jury, we are here today. I'm going to take objection to the entire attitude of the defense's team, of their supposed cultural superiority, and thinking that they can extort my clients whatever they'd like. I'd like it noted for the record, please.
I would also like it noted for the record that I object to the plaintiff's behavior. I assume that's what you meant. I assume you're not objecting to your own behavior, counselor.
He went too long, confused me, he's not following the rules. There are rules. There's a contract. There's an agreement. We didn't sign it. Okay.
Are you prepared to proceed with your opening statement, counselor?
Yes. We are here today to correct a grave injustice. The yeshiva, under the guise of education, is trying to extort my client for a tuition amount that he never agreed to. We will clearly show that if they want payment, the yeshiva must clearly demonstrate that my client agreed to a specific amount, which they concede they cannot do. We will demonstrate that without such an agreement, the yeshiva cannot arbitrarily and absurdly demand some astronomical sum that has no bearing on anything to do with reality. And furthermore, without the signed agreement, we will demonstrate that my client had every reason to assume that the same tuition he paid last year should apply this year. The yeshiva is clearly taking advantage, as you all just saw. They think they're better than us. They think they can ask for more than they deserve. You must vote in our favor.
Amen.
Okay. Order in the court. You heard both opening statements. It's working now. Vote.
As is customary, the plaintiff's case leads. Therefore, counsel for the plaintiff, are you prepared to call your first witness?
Yes, we are.
They are invited to the stand.
We would like to call Maimonides to the stand, Rambam. And we'd like our second chair to please grace the court. Second chair.
You may approach, counselor. One moment, please. Clerk of Courts, if you would swear in the witness for us, please.
Rambam, do you affirm to say the truth and nothing but the truth, so help you God?
Yes.
Thank you. Counselor, you may proceed with your questions.
Please state your name and qualifications for record.
My name is Rabbi Moshe ben Maimon, known as the Rambam. I'm the author of the Mishnah Torah, a comprehensive code of halakha.
Rabbi, for the benefit of the Beit Din, briefly explain what Mishnah Torah is.
The Mishnah Torah is a complete and organized code of Jewish law. I wrote it so that a person could know the practical halakha clearly and decisively without needing to search through the entire Talmudic discussion.
So it's not commentary or theoretical analysis?
No, it is a legal code of final rulings.
So you presided over real disputes between... Rabbi, did you only write Sepharim, or did you also serve as a judge?
I'm sorry, what?
Did you only write Sepharim, or did you also serve as a judge on courts like this one?
I also served as a dayan.
Objection, relevance, he's a witness. He's testifying. What's his role?
Objection is overruled. It is customary to establish the credentials of a witness that one is offering as an expert. Proceed, counselor.
So you presided over real disputes between people every day?
Yes, every day.
Cases involving money, debts, wages, rental agreements, damages, financial obligations?
Yes, regularly.
So your rulings not come only from theory, but from practical courtroom experience, observing how people behave, like in courts like this one?
That is correct.
Rabbi, I'd like to discuss a situation that must have occurred many times in your courtrooms. Two parties stand before a Beit Din. One says, you owe me money. The statement is clear, it's direct. If the other person remains silent, no denial, no protest, how does the halacha treat that silence?
Halacha treats it as admission.
Not uncertainty,
No.
not a maybe,
No.
but legally binding admission.
Yes.
Is this your personal reasoning, or do you codify this explicitly as law?
I codified it explicitly.
Please explain to the Beit Din where.
In Mishnah Torah, Hilchot Toen Venitan, Perek. Yes. Here's what it is. If a claim is made before him and he remains silent, this is considered admission.
And would you consider this to be more so obligatory if the demand was expressed not just clearly but repeatedly?
Yes, I believe I would.
Rabbi, does the person need to sign anything for this admission to be binding?
No.
Witnesses?
Nope.
Any paperwork or any sort of formal contract?
No.
So silence alone is financial liability.
Yes.
Why is that logical?
Because human nature is that when a person is falsely accused, he protests immediately. Silence indicates agreement.
So Rabbi, to clarify, does this rule apply only to the person if he knows about the claim?
Yes, the claim must be made in his presence or in a way that he was aware of it.
So the awareness of the claim is key.
Correct.
Oh, okay. Rabbi, please apply this principle to the case before the Beit Din. Assume a yeshiva informs the father of the tuition for his son's second year after receiving a discount for the first year. Even if earlier there had been a discussion of working it out, but the yeshiva once later stated the amount due and he did not object.
Objection? Coaching the witness?
No. No coaching.
Explaining a situation does not count as coaching, sir.
I'm fairly. You address the court, not me.
Oh, objection is
Again.
objection is currently.
Hello, kid. Objection.
Yapping, not yapping. A lot of yapping. People waiting.
Mr. Aram, I invite you to ask yourself whether or not this counselor is serving your best interests. He's walking a fine line for contempt of this court. Should you wish to continue arguing your case, I will remind you to confine your objections to those legally recognized and your behavior befitting of your profession. Now, as to the objection, as it was couched in legal reasoning, for the moment overruled, but possibility to renew. Let's see how this goes. Tread carefully, counselor. If you do overcross that line to coaching, you will have a problem. Proceed.
All right, so to summarize your testimony, when a person is informed of a monetary obligation, understands it, and remains silent while accepting the benefit, halacha considers that silence legally binding and equivalent to an agreement.
Yes.
Thank you, Rabbi. No further questions.
Would the defense like to cross-examine this witness?
Yes. Ms. Tention will, our second chair, will ask. We'll see.
If the litigant, our client in this case, initially responds and does not remain silent, does the same rule still apply?
Yeah, that makes sense.
So you are saying that if our client rebuffed the initial offer, it doesn't qualify as him staying silent?
That makes sense, yeah. No,
And that
no, I object.
The witness is reminded that you are here. Witness, you are reminded you are here to answer questions, but it is not your place to object. That is the job of the counselors. Repeat the question, if you please, counsel.
So you are saying that if our client rebuffed the initial offer, it doesn't qualify as him staying silent?
Correct.
And that would be true even if later they can't get in touch with each other.
That's an interesting point to think about.
Our client not only rebuffed the initial claim, but had no reason to think that the tuition amount would be astronomically higher the second year. That sounds like your ruling should not apply, correct? Withdrawn. No more questions.
Counsel for the plaintiff, do you have an additional witness to call?
Yes. We would like to call Rav Yosef Cairo Maran to the stand, please. Notice how our opponents stand for him.
We're aware of how to treat people with respect.
Not the wrong one. Hold him where, show him.
You affirm to say the truth and nothing but the truth, so help you God?
Yes.
Your witness, counsel.
Please state your name for the Beit Din. My name is Rabbi Yosef Karo, author of the Shulchan Aruch.
Rabbi, what is the Shulchan Aruch?
It is a comprehensive code of Jewish law that gathers the conclusions of the Talmud and the earlier authorities and presents clear final rulings so that courts and communities know how to act in practice and not merely argue in theory.
Just so I got that clearly, it was written to decide the law, not to debate it, correct?
Correct. It was written for decision and for guiding judges in everyday disputes, especially matters of money, contracts, payments, and obligations between people.
Would you say it's fair to claim that courts rely on it in financial cases?
Yes, particularly the section called Choshen Mishpat, which addresses business conduct and monetary responsibility.
In that specific section, do you state general principles that determine liability?
Yes, one of the most basic is Hakol Minhag HaMedina. Everything follows the accepted custom of the locale.
Could you explain that for the ladies and gentlemen of the court?
Monetary laws follow how normal people conduct business. When someone enters a relationship, he accepts the going prices and the ordinary expectations, even if every detail is not written, because both sides rely on that custom.
Just so I have you clearly here, the custom itself is what creates the obligation, correct?
Yes, because reliance creates fairness and halacha enforces what people reasonably expect.
Consider this case, the school discussed possible tuition assistance but never finalized a number. Later, they clearly informed the parent that no aid remained and that full tuition applied, yet he continued sending his son for the entire year. How is that viewed?
Discussion is not agreement, and hope is not forgiveness. Until a reduction is clearly granted, the regular rate remains building.
Even if they once said that they would try to work something out?
Yes, words of courtesy do not change a price. Only a completed agreement changes an obligation.
And once he was told that full tuition applied?
Then those terms govern.
What if he never signed?
Signing is not required, continuing to receive services under known terms shown consent.
Does keeping the child there all year matter?
Certainly, housing, meals, teachers, supervision, and a full year of education are substantial benefits, and one who knows knowingly receives them accepts the customary duty to pay.
Does last year's discount automatically continue?
No. Each year stands on its own, and a prior reduction does not carry forward without a new agreement.
So then what's the halachic outcome?
He pays the customary full rate according to established community practice today.
Thank you, Rabbi. No further questions.
I assume defense would like to cross-examine this witness as well?
Yes.
You're invited. Your witness, counselor.
Finally, a Sephardic authority. Salam alaikum, Habibi. Do you think we have to follow the local custom when we have an agreement saying otherwise?
Certainly not. This is a default when there's some ambiguity.
Let's explore that. Is there ambiguity in this case?
Well, they can't seem to agree on a price.
They can't agree, but there is no ambiguity. The yeshiva wants $22,000, and my client wants to pay $12,000. Does that count?
I hear what you were saying. That might be different.
If the local custom wasn't followed the first year, considering our client only paid $12,000, is there any reason to assume that the local custom standard would be relevant in the second year? Withdrawn. No further question.
Counselor, for the plaintiff, do you have a third witness to call?
We do have our third witness. It's Trumar Hadeshen, Rabbi Israel Iserle. Where's the Hogwarts store, by the way?
Welcome, Rabbi. Clerk of Courts, if you'd be so kind as to swear in this last witness.
You affirm to say the truth and nothing but the truth, so help you God.
Yes.
We're going to skip right to it. So basically, you were one of the leading post-game halachic decision makers of your generation?
Yes.
Communities didn't send you theory, they sent you real cases?
Constantly.
Money disputes?
Many.
Rent?
Yes.
Wages?
Yes.
People trying not to pay?
Very often.
So rulings were not theoretical, they were governed in real human behavior.
Exactly.
Later authorities relied on you very heavily, correct?
Yes.
Including the Ramah?
Yes.
On what grounds?
Relevance, later authorities, you're excluding, and he's testifying.
I haven't understood the objection
He's
yet.
testifying as later authorities. The counselor got up and said later authorities all accept this Ashkenazi ruling.
I said relied on.
Relevant.
It's not what I said. It's not what I said. I
For
said
second, third, fourth, fifth, sixth, how much times already?
later authorities.
Chalas.
Counselor,
Later-
for the plaintiff, can you repeat the question?
Later authorities relied on you heavily, meaning to say that this person has been cited by the witnesses they will.
Objection is
Yes.
overruled. It falls within the purview of the witness's expertise.
Great. So, later authorities relied on you heavily,
Yes.
including the Ramah.
Yes.
He quotes you repeatedly.
Many times.
So when you speak, Ashkenazic halacha also listens?
Yes.
Let's discuss one of your foundational principles. You analyze a case where where one person benefits and another person loses. Is this correct?
Yes.
Please state and cite your principle in English for everybody.
In Halach Aleph, Shin Yud Zayin, I support the Talmud's conclusion. Whenever someone benefits at another's expense, payment is required, even if he knowingly allowed the benefit to occur. The one who benefited needs to pay the full amount.
So to repeat again, if someone else benefits off of somebody else and somebody else loses money, they have to pay the full amount?
Correct.
Okay, even with permission, payment is still required?
Yes.
So if I allowed you to come to our school, it doesn't mean it's free.
Correct.
Permission is not giving me up the right to claim from the person who benefited?
Correct.
Benefit itself creates the obligation, correct?
Yes.
Okay, great. So now if a yeshiva grants a reduction, gives a part off payment, what status would the halacha give to that?
That would be called melacha.
Mechila.
Mechila. Forgiveness from paying. But melacha must be clear and definite.
So merely saying we will try to work something out is not actually committing to anything, is that correct?
Correct. Until
And-
forgiveness is finalized, the original obligation remains.
Good. So if the yeshiva later informs the parent that we can't afford a reduction, that won't be given, what happens halachically at that moment?
The law returns to its original state. The full obligation stands.
Exactly. So that's the end of story. Could you please bring up the example that you put down?
A person who says to his friend, "Come and eat with me," and he eats with them, is obligated to pay the full amount for their meal.
So that means even though he was invited?
Yes.
So even if a person was invited to a meal, he still has to pay for half of it. I am done, Your Honor. Thank you so much. Thank you for letting me establish that. It is whose tradition?
The defense is invited to cross this witness. Shall you?
Please explain to this court how this is going to work.
Ashkenazim. But if the litigant, our client in this case, agrees that the yeshiva deserves to be paid for its cost, does that mean the yeshiva can charge whatever they want?
Certainly not. They can cover their costs.
How would those be calculated?
Either what it actually cost them or what the tuition amount they would have gotten if they admitted a different student and not your client's son.
Our client could have argued that he owes nothing since he never technically agreed, but he recognizes that the yeshiva expended money to support his son and is willing to pay for those costs, but not the astronomical sum that the yeshiva is demanding. So according to your own argument, our client should not be subjected to the bloated and absurd full amount, correct? Withdrawn, no more questions.
Are there any further witnesses for the plaintiff to call?
Those are all the witnesses we need for this case.
So you rest your case?
We are resting our case right.
The defense is welcome to present its witnesses. Who do you call?
We call Rav Ashi. Chacham Yosef Shaprun will represent the defense.
You affirm to say the truth and nothing but the truth?
Yes.
Your witness, counselor.
Please state your name for the record.
Ravashi, no last name.
How come you don't have a last name?
It wasn't a thing back in the day around the year 500 CE in Babylon.
Please tell the jury about yourself.
I'm actually one of the compliers of the Talmud Bavil. I'm also often a participant in part of the discussions.
So you would say that you understand the Talmud?
The burden of proof is the litigant who wants to collect, meaning if you want someone to pay you, it's on you to prove they owe you the money and how much they owe.
This is what you said in Bava Kama 46b, yes?
Yes, it's a simple matter of logic, in the same way that a person who has pain goes himself to a physician.
So in your expert opinion, who is the burden of proof on this case?
The yeshiva has to demonstrate that the father owes money and how much they agreed to pay.
No further questions at this time.
May we cross-ex, please?
You are invited to cross this witness, yes.
Ew, smell that. It smells like tamarind. Must be Dawood sweating over there. All right.
Again, objection.
Rabbi, I'd appreciate it if you let me proceed with mine. Thank you. Rabbi, please answer the following set of questions with a yes or no. Your source states, you stated the one who seeks to take money from another bears the burden of proof, correct?
Yes.
Yes or no? This rule describes courtroom procedure.
Yes.
It tells the Beit Din who must bring evidence.
Correct.
It does not cancel debts automatically.
Yes.
It does not say that someone who received services may keep them for free.
Correct.
It simply requires the plaintiff to prove the facts.
Yes.
Once facts are established, the Beit Din may collect money.
Yes.
If the plaintiff proves that the defendant knew the price, continued the arrangement, and accepted the full benefit, that would satisfy proof?
Good question.
Can they keep slandering us freely? No further questions, Your Honor.
Objection.
Yeah,
relevance.
that's sustained. Thank you. See, and it shall be stricken from the record. All right. Any further questions for this witness? No? All right, this witness is dismissed. Thank you. Does the defense have an additional witness to call?
Yes, we would like to call Rav Moshe Israelis, someone who the defense counsel should be intimately familiar with. Ha'am Shukron, your help.
You affirm to say the truth and nothing but the truth?
Yep.
Please state your name for the record.
Rav Moshe Isserlis.
What kind of last name is that? Are you even Jewish?
It's Polish, as in Ashkenazi Jews.
I guess nobody is perfect. Tell us a little bit about yourself, please.
We lived in the 1500s in Krakow, Poland, and wrote glosses or comments in the Shulchan Aruch.
Which was written by Sephardi, correct?
Yes, I often add in Ashkenazi practices as well as additional cases that the Shulchan Aruch didn't address. My comments form the basis of mainstream Ashkenazi halachic rulings.
Objection, racism?
Sustained. Keep the questioning within the lines of the legal issue at play.
It's relevant to the legal issue of why it should be binding.
Yeah, I'm about to get to it.
To ask. Let the man speak. Let him speak.
I will retract my ruling and wait pending the next question.
So the Ashkenazi-run yeshiva administration should not only be intimately familiar with your rulings, but consider them binding?
I presume so.
Objection. Says who?
Says you.
Overruling the objection, I see the relevance.
So please tell us what case you discuss in Shulchan Aruch, Hoshena Mishpat 333.8.
So in English, it says, a chazan who was hired by the leaders of the city for a year with specific terms, and then the next year was rehired by the city's new leaders without mention of any conditions, the terms are certainly the same as those of the first year.
So in your expert opinion, without having reached an agreement with the yeshiva in the second year, what should my client have been expected to pay as his tuition?
He should have assumed that if it followed the same pattern as the first year at $12,000.
No more questions.
Objection. Selfies in the courtroom. That's got to violate something.
Both counsel are reminded to not only maintain decorum, but conduct themselves as exemplars of decorum. Counsel, this witness is yours to cross.
I'd like to examine and explore your ruling regarding the chazan. Is it comparable to the situation that we have here today? In your case of the chazan, no new terms or contracts were ever offered. Is that correct?
Yes, correct.
Would you rule the same way if another contract was offered in its stead?
Perhaps not.
Perhaps not. Would you, probably yes, but would you say in the same situation where a plan was in place and the yeshiva asked you to be in touch regarding the amount needed to be paid, and after my client reached out numerous times, multiple ways, and this father completely ignored the new agreement what would happen then?
That's an interesting question.
Interesting. Okay, we'll leave it at that. We rest. Thank you. Shabbos nap.
As there are no further questions for this witness, he is dismissed. Thank you. Any further witnesses for the defense?
We'd like to call the author of the Pitzei Choshen, Rav Avram Rav Yankel Yeshaya Bloy.
They are invited to the stand.
You affirm to say the truth and nothing but the truth?
Yeah.
Please state your name for the record.
Rabbi Yaakov Yankel Yeshahai Bloy.
You look a little younger than our previous witnesses.
I lived far away more recently, having only passed away in 2013 in Jerusalem.
Aside from being...
He's not alive.
Is it a hearsay objection then?
Yes, so. It's hearsay.
Your Honor, we're looking at him.
Seeing as in this case he has miraculously found a way to present himself before the court, I'll allow it. Proceed.
Aside from being Ashkenazi, which you clearly are, what else can you tell us about yourself?
I wrote many books, including a whole series about adopting Talmudic monetary law to modern times.
Seems pretty relevant to our case. Can you tell us what you wrote in Pitzei Choshen, chapter 8, number 4?
So what I basically wrote is, if a worker demands a specific amount and the employer says, we will work it out, it is considered as if they have never reached an agreement.
So to make sure I understand correctly, how does this apply to our case?
Even though the yeshiva asked for a specific amount, when the father refused and they failed to reach an agreement, we do not automatically assume that the original amount, meaning $22,000, is agreed upon the moment.
No more questions.
Is the plaintiff seeking to cross this witness?
Yes, we are ready to cross.
Does he need the stuck box?
No, that's for your client to pay.
We can continue with our case, okay?
This case you were discussing is a case where negotiations before the employment begins?
Correct.
At that stage, no work has yet been performed.
Correct.
No labor has been provided.
Correct.
No benefit received.
Correct.
Your ruling is describing only the negotiation stage.
It would seem so.
Not... Sorry, I'm so crazy. Not after services were already given.
Correct.
Because once the worker actually performs the job, payment is required.
I'm not sure that's so simple.
Halacha does not allow somebody to receive labor for free.
Correct.
So your source does not say that the negotiations erase payments after performance, does it?
No.
So this ruling does not apply after a full year of services were already given.
Correct.
And here the yeshiva has already provided housing, meals, teachers, a complete year of education.
Yes.
Thank you. No further questions.
The defense rests.
Okay, at this time then, the plaintiff and defense will be invited to make their closing statements. The plaintiff shall lead the way per custom.
I request 60 seconds.
No, counselor, we're following the procedure in this case.
Always asking for more than they deserve. We're following a pattern. We're noticing a pattern. Agree with it? Stuck a box to collect extra money from the jury.
My opponent is mentioning that we would like more. We would just like what we are owed. You can't go to a store a week after a sale and say, hey, give me the price from that sale that took place a week ago. We have proven that if somebody is quiet after seeing and hearing that there is an updated price, they should be obligated to pay. We have discussed how we go after the law of the land, and we say if this is common nature, where the price is established, a person should pay that full price. And we have also established that in a place where a person benefits and another person loses out the money, they need to cover that. In this case, we could have had another student sitting in that chair, paying full tuition, like most of the students. But no, we have someone pulling away. You guys know what the right thing is. We count on every single person in this room to do the right thing, or else bedlam will exist in our society. People will decide never to pay for things and just wait to be chased down, to come to court here, be made fun of and berated by a counselor, and then we walk away without our money. We ask you guys to please side with us as the plaintiff, and we should all have a great cholent on Shabbos. Amen, Selah.
That was a chilling comment. We're going to need some kameen.
Defense is reminded that while your client may not end up paying in full to the university, costs for sanctions are a very real thing. Please come to the stand.
Do the right thing. This is a tale as old as time. The big guy taking advantage. The establishment looking at people as other and saying we can take more than we actually deserve. We get it. It costs money to run a yeshiva. They have to have a dorm and food. But let's not pretend for a moment that this is the Ritz-Carlton. My client's son had to wear a raincoat inside in the Jerusalem winter to make sure he didn't get wet.
You guys didn't pay tuition.
The food is barely edible, if that. They deserve money. But not some absurd number that they came up with. And that's why the first year they agreed to $12,000, because they can manage their costs instead of some inflated sum that they come after my client to ask for. That's absurd. But more importantly, there was no agreement that second year. It's true that they asked for $24,000, but that number is completely random. My client didn't take that seriously, and you know why? Because the first year, the yeshiva said, you know what, we'll just cut it in half. Obviously that number is made up and fake. That has nothing to do with reality. They came down 50% the first year. When they offered that the second year, that's the opening bid in the negotiation. That's how things work. You don't just get a price and say, okay, sure, I'll pay. Our client knew that. Without actually working it out, they let his son back into the yeshiva. Respectfully, counselor. We've demonstrated from the Pitchei Choshen. Agreeing to work it out does not mean that the yeshiva then gets to go and say, oh, but we asked for this originally. That's irrelevant. And because of the only existing contract is the first year, the Ramah showed that we should follow the pattern from that first year. And that's what he should pay. And when it's clearly an Ashkenazi-run yeshiva, and perhaps with a tad of an inflated sense of cultural superiority, perhaps, with the repeated comments throughout this trial, this should matter to them a lot. The Gemara clearly indicates that it's the yeshiva's burden, not just to prove that we owe money. We do, but the amount as well. And they failed. You must therefore rule in my client's favor. He should be responsible for $12,000 only. Shabbat shalom u'mvorach.
Okay. Shh. The moment we've all been waiting for. The audience will open up their laptops. Open up poll number 2, which is the final poll. Shh. Jury, deliberate amongst yourselves. Write down yes or no. The question that you have in front of you is there. The question that you have in front of you is there. You do the same. Vote as you want. And the judges will deliberate.
While you're talking, just a quick announcement while you're talking. If anyone is looking for a great program for Israel for next year, Jake, Edmund, Leon, there's no Torah Tuesdays. We go to your limb. We have great ribbon with loving rule.
Bailiff, I am about ready to have counselors for both sides removed.
Okay. Has the jury come to their conclusion? No. That's not how a jury works.
I'm thinking about it. There's a couple different
Each
laws
jury member will vote as they see fit, and then you'll let me know what the majority is. Each jury will vote as they see fit, and then tell me what the majority is. Boys and girls, as you can see, law is complicated, it is nuanced, and obviously we did it very, very quickly. But there's some fundamental things that need to be thought about. What is the status quo? If somebody says no and the other person says yes, what's the custom of the land? On whom is the burden of proof? How do you prove that you're owed a certain amount simply because you asked for it? Is it because you asked for it and the other person didn't deny it? Or denied it but didn't take away their child from there? At the end of the day, his child benefited from the yeshiva. At the end of the day, he said, no, I'm not willing to pay that amount of money. It's not so simple. And it requires, obviously, a tremendous amount of thoughtfulness. We're going to hear right now what the juries and what the judges, and I'll let you know what the audience said. The initial poll that the audience gave was 27% in favor said yes, that the defendant, Dawid Azran Bar Yochai, should pay, and 73% said no. That was the initial poll. That was the initial poll. The initial poll. The jury, both middle school and upper school, majority voted no. Let's hear from the judges and then I'll reveal. Actually, we'll do the audience. The audience, surprisingly, voted the second time around. 24% said yes, 76% said no. And
the audience and the jury have decided that the father does not owe the university. This bench disagrees. Based on what we have heard, the assumed facts. Take him out. Jewish. Now, the basis of this ruling came from the party's own stipulation of the facts. At no time was substantial evidence offered that the actual cost of educating a student is not $24,000. According to the record, that $12,000 came from a scholarship. Therefore, when the defendant agreed by consent and through his silence and action to send his son for the full year and received the full benefit of the full year, the university, therefore, was entitled to what it cost for that child to be housed, fed, and educated. It was granted, there was a discount that first year, but it has been made clear through the testimony that that discount was not something that could be assumed year to year. That it was understood that that discount was for a year, and that the sticker price on offer was $24,000. At this point, frankly, the university is probably entitled to the full $24,000. But as they have requested $22,000, this bench rules that that is the amount to which they are entitled.
congratulations. Ladies and gentlemen, wishing you all a Shabbat Shalom u'mevorach. Thank you to the judges. Thank you to the bailiff. Thank you to the counselors. Thank you to the witnesses. Thank you to everybody for participating.